Good evening, everyone, and welcome to Hare Court Pupillage Open Evening. My name is Tom Poole. I'm Head of Pupillage and Recruitment. Before I introduce everyone, let me just tell you something about the format of this evening. Owing to the number of people joining, we're running this as a webinar, but we do want it to be as interactive as it can be. So please do ask anything you would like to know about Hare Court, about pupillage at Hare Court, or about the application process generally by using the chat function, and we will do our best to answer as many of your questions as possible. We're going to try and take up no more than about 45 minutes of your valuable time this evening. I will start by telling you something briefly about Hare Court, what pupillage looks like with us. Anna Gattrell and Tabitha Hutchison, who are our two junior tenants, are then going to tell you about their experiences of pupillage and life as a junior tenant. Nick Lee will then talk about pupillage applications and give you some practical tips on how to make your application stand out. The aim is that that should take no more than about 20 minutes or so. So the second half will then be a question and answer session, which is by far the most important and hopefully interesting part of this evening. We've had quite a few questions posed already, so we will be answering those. But as I've said, please feel free to ask more via the chat function as we go along. So who do we have with us this evening? In no particular order, other than the order in which people appear on my screen, we have Charlotte Pope-Williams. Charlotte, as well as being an award-winning member of Chambers, is, along with Daniel Goldblatt, joint head of our mini pupillage programme in Chambers. We've got Chris Loxton. Chris is one of our senior juniors with an excellent broad civil practice, and Chris is also one of our pupil supervisors in Chambers. We've got Ben Channer. Ben too is an excellent senior junior in Chambers, and as well as being a pupil supervisor, Ben is Chambers Equality and Diversity Officer. Nick Lee is one of our extremely talented juniors whose practice encompasses all aspects of Chambers work and who you'll hear from in a moment. Tabitha Hutchison and Anna Gattrell, as I've already mentioned, Tabitha and Anna are our junior tenants, which means that they both successfully completed pupillage in July and have already started building excellent practices in Chambers. We've got James Donovan, who is Chambers senior clerk. James, I think I'm right in saying, has been in Chambers since 1985. So there is nothing that he doesn't know about Chambers and hasn't seen. James oversees the development of all members' practices and runs the practice management team. And last, but by no means least, Lisa Happe. Lisa is our Director of Marketing and Business Development. Lisa joined us in early 2023 and since then has been instrumental in ensuring that Chambers continues to go from strength to strength. So I'm now going to ask everyone to turn their cameras off, and so unfortunately you'll be stuck with me for the next 5 minutes or so, but then everyone will come back for the Q&A session in 20 minutes or so. So what can I say about Hare Court that you can't find out for yourselves from our website? Well, when I interviewed for pupillage back in 2000, it was the friendliness of Hare Court which struck me above all, both the friendliness of the clerks and friendliness of other members of Chambers. And I'm very pleased to be able to say that that remains as true today as it was then. Now, in part, that's probably a result of us being a smaller set. We currently have some 40 or so members, but more importantly, it is also part of the ethos of Hare Court. And whilst we have grown somewhat in the 78 years since Chambers was formed, and we continue to grow incrementally, that friendliness is something of which we are proud and wish to retain. What else would I say marks Hare Court out? I think undoubtedly it would have to be the breadth of work that we do and the opportunity which exists in Chambers to experience different types of work and to develop the sort of practice that you want without being forced down one route to the exclusion of another. Members in Chambers provide a wide range of advocacy and advisory services, both in the UK and internationally, both at first instance and on appeal. By way of some recent examples, members advised on the Bitcoin protocol framework. They were involved in the tuna bond scandal, which was Mozambique's biggest corruption scandal. Members are involved in a number of public inquiries, such as the UK COVID inquiry, numerous Russian aircraft disputes, FCA judicial reviews, very many appeals to the Supreme Court, and in particular the Privy Council, where members appear almost on a weekly basis. We're also ranked by the legal directories in numerous practice areas across a wide range of commercial and common law work. We've got a tier 1 ranking in the Legal 500 offshore guide. We're band 1 ranked in Chambers and Partners for travel and international personal injury work, and individual members are ranked as starred individuals and our juniors as rising stars in both Legal 500 and Chambers and Partners. 6 members were also recognised this year in the pro bono recognition list, and we were shortlisted this year by Legal Cheek for Best Chambers for Quality of Work. Now, there are, of course, some areas in which we do more work than others. I would say that our 3 main areas are commercial, personal injury and travel, and international. And by international, I mean international arbitration, appeals to the Privy Council, and our offshore work. But as I've indicated, members also practice in many other areas. So you've got civil fraud practitioners, people practicing in financial services, insolvency, public law, inquests, inquiries, employment, prof-neg, property, and construction. So why apply for pupillage at 3 Hare Court? For me, there are 3 main reasons. First is what I've touched on already, the quality and the breadth of the work that Chambers has to offer. And as a pupil, that is something you will be immersed in from the very start of pupillage. One way we seek to achieve this is by having our pupils work with at least 6 and sometimes 7 supervisors during their pupillage year, and thereby experience 6 or 7 different practice areas, which we think is a unique opportunity. The second aspect is the emphasis we place on advocacy, which is reflected in our advocacy training programme during pupillage, and the fact that all of our pupils have a fully practising second six, which sees them regularly in court week in and week out. And third and foremost is the people. As I've already mentioned, Chambers is a friendly and welcoming set with a strong community feel. What does pupillage look like at 3 Hare Court? Well, as I've said, it's not terribly interesting really listening to me. I'm going to let our website do most of the heavy lifting here, and I would encourage everyone to go to our dedicated pupillage page, as everything I'm about to summarise in the next minute or so is set out there in much more detail. But by way of nuts and bolts and give you a heads up, all applications for pupillage must be made through the Pupillage Gateway. That opens next year, 2nd of January, as I'm sure you will know, and closes on the 6th of February. We are offering 2 fully funded pupillages commencing October 2026. The award is £67,500. The purpose of our selection process is really to identify pupils who we anticipate will be outstanding candidates to join Chambers as tenants and strengthen our areas of practice. And our aim has always been, throughout the time I've been in Chambers for the last 20 plus years, to offer pupils tenancy at the end of their pupillage, and we have an excellent record of offering tenancies to our pupils. In terms of the process, again, it's all on the website. We operate 2 rounds of interviews. First round interviews take place in mid to late March next year. There'll be remote interviews because our experience over the last years is remote interviews work well, certainly first round interviews. They generally last about 15 to 20 minutes. You're asked a range of competency questions and questions about your application. And then second round interviews take place in person in Chambers, probably beginning to middle of April next year. They're a bit longer. They consist of an advocacy exercise followed by some further competency-based questions. As I said, though, do look on the website. There's much more information, not only about the process, but also about what is like being a tenant, being a pupil, sorry, in Chambers. So if I can invite Tabitha and Anna to turn their cameras on and tell us something about their experiences of pupillage and life as a junior tenant. Perhaps I can start by asking what makes pupillage, in your view, at 3 Hare Court stand out?
Thanks, Tom. I would agree with much of what you've said, in particular in relation to the variety of work, which is often at quite a high level. And I can't really think of any peers who got the range of experience that I did, whether in first or second six. One of the things that is unique is that we have this really broad spectrum, but without really any criminal or family work, save for that which would arise in the Privy Council. And I remember I'd ruled out quite early on anything to do with crime or family. But I also didn't want to focus only on one specific area. I didn't want to go to a set where I would only have the opportunity to do personal injury, or I would only be doing commercial work. And I was really pleased to get an offer from Hare Court for that reason. And the pupillage lived up to its expectations in that regard. And I think throughout pupillage, the work that I was doing was really varied. I did an employment law trial, lots of personal injury trials. I looked at insolvency work, did some drafting of papers in relation to breaches of shareholders' agreements, looked at cases which involved questions of applicable law, jurisdiction. And I'm not sure that there's really anywhere else at the bar where you have that opportunity to experience such a range of work from the get-go. So I think that would probably be my standout. I don't know if Tabitha has anything to add.
Yeah, so for me, it's the advocacy really, which again, something that Tom's already touched on. It's something that a lot of you will have heard sets talking about. Yes, we have a practicing second six, you get advocacy experience. But in the case of Hare Court, it really is a standout feature, in my view, for three reasons, really. There's lots of it. It's very varied, as Anna's touched on, as has Tom, and it's high quality. And those are really important points. There's lots of it in the sense that Anna and I have been in court 3 to 4 times a week on average in different matters. Sometimes 5. You're thrown in at the deep end at the very start of second six, which obviously seems terrifying at first, but the clerks really have your back, as do your supervisors and other members of chambers who are always open for last minute or silly questions. And that's also against the backdrop of the advocacy training, which is on offer, which has multiple hearings and a trial in a mock case that's based on a real one. So you're really well prepared. But in terms of the sheer quantity, I mean, I'd done more hearings kind of in my first couple of weeks than peers of mine did in their first couple of years of practice. On that note, I think somebody's asked in the Q&A box, don't most sets offer practicing second sixes? I think the short answer is no, and particularly not practicing kind of court time second sixes. That's particularly unusual at the commercial bar in my experience, and it's a standout feature at Hare Court. I think even as compared against other sets in the kind of areas that we do, it's very varied work, as Anna said, but it's also high quality. So it's not just advocacy experience for the sake of it. We're not just being sent off to do kind of bulk work, grunt work. Obviously, you know, you start at the bottom and you do the small stuff, but we're also doing, you know, relatively significant work for our level, like fast track trials, multi-day employment trials, as Anna's mentioned, and across a whole range of practice areas. So whereas other sets might only be doing kind of small claims and part 3 hearings at this stage, I think partly thanks to Hare Court's reputation of starting advocacy early, we get some good stuff.
That's all very good to hear, I have to say. I suppose question, how did you find the transition then from first to second six, and how did Chambers, assuming we did help with that, how did Chambers help with that transition? Either Anna or Tabitha.
Well, you'll be pleased to know I think Chambers did help. I will be honest, I was quite apprehensive about making the transition. I definitely didn't feel ready, and that's not to say Chambers hadn't prepared me, but I think it can definitely feel a bit daunting. It got to sort of mid to late February. Our second six started, I think the second week of April it would have been, and I'd started to see things going in the diary, and it all felt quite real. Quite exciting, but still a little bit nerve-wracking. And I think at around that time, into the new year, everyone in Chambers starts to really emphasise that they are here to help. Whether that's your supervisors, whether that's junior tenants. And I think it's also possible at that stage to start liaising with the clerks and other junior members to go and see hearings with them. And something that really assisted me, and if I can speak on her behalf, I think Tabitha as well, was a chat with Nick and Rory, who were the two tenants a year above us, effectively. And they spent a long time talking with us about what to expect, certain hearings we might come across, kind of top tips. And that's not to say that was the only time they spoke to us. I mean, I pestered them constantly with numerous questions, but that was just an occasion where they really dedicated the time to speak with us. And I would also add that the clerks are really helpful and communicative, and they really assist with making the process quite smooth and seamless, to the point that you almost don't even notice it or think about going to court. They just, things go in the diary, they explain what those will involve, they get the listing out to you. And I would also add that this isn't a Chambers where, certainly in my experience, you feel pushed into very last minute hearings in the first week of your second six. You're always encouraged to take things on, but it's not a situation where on a regular basis it's 6 p.m. and suddenly papers come in for the night before and you're expected to be in Newcastle on a very complicated matter. So the clerks are quite alive to that as well, which I think helps. So overall, I would say that Chambers is generally just very supportive, and people are always on hand to answer any question, whether big or small. And really, after the first couple of hearings, you just get into the swing of things, and it feels like you've been doing it for quite a while.
Tabitha, anything you've got to add about the transition from first to second six?
I mean, I think Anna's covered it all, really. I suppose if she's covered that aspect of transitional stuff, I could perhaps share my experience of the second transition, which is from second six, end of pupillage, to being a junior tenant, which we've been through very recently, about a month ago. It's very exciting, obviously. Huge relief. Although I should say that Chambers has a good track record of keeping people on, which is another a very good track record, in fact. So that's another major pro when doing pupillage in Chambers. The beauty of doing a properly practicing second six is that it makes the transition to tenancy quite seamless. So on top of all the kind of practical regulatory requirements that you're suddenly being faced with, and all the sort of excitement and the nerves, you're not also thinking, and now I have to go to court for the first time ever. So it was a pretty seamless transition work-wise. The diaries stayed chock full of really interesting work, and it's obviously getting all the more interesting and kind of high level the further we continue in our practice development. But there's also simultaneously more of an opportunity now to start to hone down what we enjoy, what we're interested in our practice. So I think both of us are choosing to keep our practice quite broad at this stage. That's something that's completely possible and even encouraged in Chambers, but others at the junior end have started to kind of hone into one area or another, or several areas, and we both had practice reviews with the practice management team, the clerks, within a month of finishing pupillage, where we just sat down and we felt comfortable being, or if I can speak for both of us, it was encouraged for us to just be very open about what we like and what we don't, and where we want to take our practice. So feel very supported in that regard, and those will be at regular intervals now going forward. Some of the work that I did during pupillage for people in Chambers has directly translated into paid work now. So one of the things that's encouraged in chambers during pupillage is to do bits of work for silks in chambers throughout, which gives you an opportunity as a pupil to impress senior members of chambers with the tenancy decision in mind. But also on a practical level, I've, within the last month, been working on 3 different matters for silks and senior juniors in chambers on what's called a deviling basis. So you're sort of paid to do research or first drafts of things. So that one of which directly came out of a first draft advice I'd done for one during pupillage. And aside from the work, I mentioned all the practical requirements. I certainly have needed a fair bit of hand-holding in that regard. It's a weird and wonderful world, and we've been very lucky to have a lot of support in that respect from our chambers manager and the clerks and administrative staff, just kind of telling us what forms to fill in and all that sort of thing.
Super, thank you both very much. I can see there was one question directly relevant to you before we hand over to Nick. What would you both say was the most challenging part about pupillage? But I know, Tabitha, you've got a prior engagement. So what I'm going to suggest is that Anna mulls that over, and when we come to the Q&A in 5 minutes time, then you can answer that question then, if that's okay. So thank you both very much. And Nick, perhaps you can join us now and give us some practical tips on pupillage applications, how you make them stand out.
Yes, thank you, Tom. Good evening, everyone. As Tom said, I'm one of 3 Hare Court's junior tenants. I secured pupillage in 2021, started pupillage in 2022, and completed it in 2023, and became a tenant in October of that year. In the next few minutes, I will outline my 6 top tips for making a successful pupillage application, having marked in the most recent application cycle chambers pupillage applications. I will obviously specify where these pieces of advice are particularly relevant to 3 Hare Court, but more generally you can apply these tips to any application you're writing. So the first piece of advice, and it's quite obvious, is preparation and organisation. And by that, of course, I follow the old saying, if you fail to prepare, prepare to fail. There are many ways to organise yourself when you are approaching an application cycle. One that I recommend is to have a centralised database, be it on a spreadsheet or on a Word document, where you have all the information at your disposal about the chambers you're applying to. So the relevant deadlines, well, they'll probably all be the same through the gateway, but there may be some off the gateway, the pupillage award, the criteria by which your applications will be assessed, the deadlines for any other particular pieces of work you might be interested in applying for, be it a mini pupillage in that particular cycle, and so on. And if you organise yourself in this way, you can set realistic expectations about the number of applications you can produce between now and the deadline whenever it is in a few months' time. The second piece of advice is to think very early on, before even making the application, what your connection is to particular chambers. Now, with that, you need to research each chambers quite carefully. In the case of 3 Hare Court, as Tom outlined earlier and Anna and Tabitha went on to explain, we are a broad chambers. We have within chambers many different practitioners across a full gamut of civil and commercial law. And of course, it's important that you understand what that entails, what practice areas that we can give you exposure to if you do pupillage with us. But you must make sure also that you have some connection to those areas. I think it was Anna who said that we don't have any criminal or family work here, save for anything in the Privy Council that might be relevant. And so if all of your experience is geared towards those areas, then unfortunately we might not be the right place. And indeed, if you're only able to draw on those sorts of areas of experience that you've had, then it might be difficult to substantiate an interest in areas of civil and commercial work. So you need to think about the connection you have to each chambers you're applying to. Third piece of advice is your structure. It's a piece of written advocacy, an application, and it's intended like any written advocacy, to persuade your audience, in this case, someone like myself reading your application and the other assessors, who, by the way, have very limited time when reading a large number of applications. So one way to stand out is, of course, to use a clear structure. In general application questions about why these chambers or why this area of law, the rule of three is a good rule of thumb. That's 3 distinct paragraphs with your particular arguments attached to each paragraph. It could be 2, but certainly don't labour the number of paragraphs that you use. And when it comes to competency-based questions about describing a time that you've had to persuade someone, or describe a time when you've had to work in a team effectively, and so on, one recommended tip is the use of the STAR application form, and that is situation, task, action, result. The fourth piece of advice is to adopt a clear and concise writing style. I mentioned just a moment ago, this is written advocacy, and of course you have to keep it as persuasive as it can be in the constraints that you have. So I recommend keeping it simple. It's not the time to display your knowledge of the English language or your ability to use complicated grammatical structures. It's the time to be impactful with your written advocacy and immediately grab the attention of your reader with clear writing and a concise answer to the question before you. Fifth piece of advice is evidence. And I'd say that this is possibly the most important piece of advice. Like courtroom advocacy, you can't simply make an argument or a submission without backing it up with relevant authority. You need to back up your statements with evidence that you actually have a material interest in a particular area of law. And in our case, the areas of law that we practice. And we would say that it's important to display a wide range of evidence and not rely solely on one example to illustrate your interest across all the questions that you're asked. The final piece of advice, and this is again obvious but very important, and that is to proofread each and every application carefully. Make sure that there are no typos or grammatical mistakes. It will reflect badly, and when I read applications and see that they haven't been properly proofread, they are unfortunately immediately, in my mind, marked down. And the second thing, of course, is make sure that you've given it to someone else other than yourself. A second set of eyes cast over an application can really help you to be convinced that you've actually managed to persuade your audience that your interests are genuine in a particular chambers. So there are my 6 top tips, and very much wish you the best of luck with applying.
Thanks very much, Nick. And if I can ask everyone to turn their cameras back on, we will now have the Q&A session. So what I will do, I will sort of adopt the role of Fiona Bruce for question time. I will pose the questions. I will deal with some of the questions that people have sent in advance, and then I'll try and work my way through the live questions, some of which I've done my best to answer already. So let's start with a question that we had submitted. How, if at all, does Chambers use its mini pupillage scheme when identifying potential candidates for pupillage? So I think best person to ask this, Charlotte, given your responsibilities for mini pupillage, why don't you take this first question?
Thank you. Absolutely. Well, I think the first point to note is that mini pupillage is not a precondition to any pupillage offer or pupillage application in Chambers. So you don't have to do a mini pupillage in order to have a successful pupillage application at our set. But actually more, it's an opportunity for us to showcase to you our members and the types of work that we do. We've worked really hard to have a mini pupillage programme that gives sort of a broad range of experience and tries to engage with a broad range of members. So really it's for us to showcase to you why you might want to think about applying and trying to attract talented individuals to apply to our chambers more generally. And also it's a really important opportunity for you to have an insight into whether what we say about the friendliness and inclusiveness of chambers is true, and if this environment is one that might suit you. So it's not something that we use as part of our assessment criteria for pupillage per se, but we really want to show you what a great set we are and give you the opportunity to make an informed choice, if possible, by undertaking some work experience with us.
Thanks, Charlotte. So next question, what areas of law are pupils most likely to cover during their pupillage? And perhaps linked into that, I see one of the live questions, similar theme. Well, perhaps I'll take that one. Let's focus on this one first. So what areas of law are pupils most likely to cover during the pupillage? Ask one of our supervisors. Perhaps Chris, you'd like to answer this question.
Sure, Tom, thanks. Well, given what Tom said about the fact that you're potentially with up to 6 to 7 pupil supervisors, that's usually the whole full gamut of our work. So that's predominantly international Privy Council work, commercial insolvency, PI, travel, aviation, which is a lot of what I do, and public law. So those are I think there's about 6 there. So you're going to be exposed to most of them, but it slightly depends on who. We've got more pupil supervisors than actually are available in any given year. In other words, we've got more than 6 or 7 that we actually assign. So it may be that you'll see more or less of those pieces of work, or may not even see particularly 1 or 2, but you almost certainly will see the majority of those. Again, it depends on how long you're on a case with a particular supervisor. It could be a long trial. Or it could be short bits of work. So it rather depends, but you're almost certain to be exposed to the vast majority of the things we do in the main the time that you're with us.
Thanks, Chris. How often is a second 6 pupil sent to court, and typically what type of cases will they be doing? Perhaps invite James, our senior clerk, to give some insight there.
Yeah, hi everyone. I think Anna and Tabitha may have already answered that, but I think in the first month or so, it's probably 2 or 3 times, but after a couple of months, it could be sort of 3, 4, and sometimes 5 if we've got work available. It can be a mixture of small claims, some fast track trials, applications and interlocutory hearings, mainly in sort of personal injury, travel, commercial insolvency work.
Thanks, James. So someone's asked, how does Chambers treat pupils with a waiver? Perhaps I'll deal with that one. I think what I would say is Chambers is committed to providing all of our pupils with a full 12-month pupillage experience to ensure that they receive not only thorough training, but as everyone's indicated, sort of exposure to all aspects of practice within our core areas. And that really reflects our belief that a complete pupillage best prepares people for tenancy and then a successful career. That said, we obviously understand that waivers from the BSB may sometimes be granted for exceptional circumstances. So you may have prior relevant experience, for example. In those cases, while we will always comply with the BSB guidance, we generally look for candidates who align with our preference for a full pupillage term to maximise their development and exposure to life at Hare Court. But that's not to say if you've got a waiver, you shouldn't be put off applying. But to give you a heads up, we really will be looking for people to commit to a 12-month pupillage with us generally. Right, another question. Perhaps this probably one for you, Lisa, as Director of Marketing and Business Development. Someone has asked, are pupils involved in business development and marketing? And if so, how?
Yes, hi everyone. Yes, I think at Hare Court, we take a view that all pupils will be successful and we want them to be successful. So we support you from the get-go. So that means that we all support you in terms of marketing and events. So any seminars or receptions or entertainment that we put on for clients, we all try to encourage the pupils to attend. We recently had a large drinks reception at the Inner Temple a few days ago, and we had our current pupils attend. I think last year it may have been week 1 for Anna and Tabitha, and we had our commercial insolvency drinks reception, and they were encouraged to come and attend and meet some of our clients and introduce themselves to the rest of the team and other members. So I try to encourage all the pupils to participate in all of our external events and internal events. So we have, lunches, Thursday club lunches. We will do the London Legal Walk. So we treat pupils as if they're, part of Chambers with a view that they're going to be tenants after 12 months.
Thanks very much, Lisa. Someone's asked, what are the main do's and don'ts during pupillage? I think this has to be one for a pupil supervisor, surely. Ben, why don't you field that question?
I will have a go. Thank you, Tom. I think in terms of don'ts, what I would say is as the big one that's right up there is don't try and be something that you're not. And what I mean by that really is frankly just be yourself. And don't come into pupillage with any preconceived ideas about what a barrister is or what a barrister looks like or what a barrister sounds like. Just be yourself, because ultimately a year is a long time to be trying to be something that you aren't, and people will see through it, and you'll have a far better time and a more enjoyable time going through it as yourself. In terms of do's, I think following on from that, I would say do make the most of pupillage as a learning experience. Obviously the law and procedure, but also the soft but crucial skills of a barrister in terms of dealing with clients, how you interact with other members of chambers and practice management team. As you've heard, you'll have a number of supervisors, 6 or 7 at 3 Hare Court. They'll all have a different approach to advocacy, to drafting, to written work, and you can use that really as a painting box of colours that you can pick up and add to your growing level of experience to then build into your second 6 and then into your career.
Excellent, thank you very much, Ben. Now perhaps that question that I think we've given sort of Anna long enough to think about an answer for. Let me find it. What was the question? What would you say was the most challenging part about pupillage?
Yeah, I think I've reflected, and it does come with its challenges. And probably for me, it was time management. I do consider myself to have relatively good time management skills, but this is a job where there are often competing deadlines and there are also unknowns. And when I say unknowns, I mean things like hearings that aren't going to go ahead because it's settled in advance because there's no judicial availability, which happens quite a lot, as well as hearings that settle on the morning. So you spent a long time preparing for a case, and then you show up to court and you realise actually the scope for settlement here, my client really doesn't want to go ahead, let's see what we can do. As well as that, in second 6, you'll be doing or trying to do work for your supervisor and other members of chambers as well. So there's quite a lot to balance. And I don't really have much helpful advice on this, save for you do just get used to it and get better at it. And I think communicating with the practice management team is really helpful because they're always open to hearing any concerns you have, or same with speaking to your supervisors as well, and getting a sense of what deadlines are for them. Because one thing I would add is that all of my supervisors were really conscious of other work that I was doing and very helpful in kind of maybe being flexible on their deadlines so I could make sure my own work was taking priority really. But yeah, time management can be difficult, but it's definitely something you do just get used to.
Super, thank you, so Anna. I'm going to try and sort of merge some, because we've got so many questions to get through. I'm going to probably not do service to them all and try to merge one into a question of my own. Should candidates show an interest in all of our practice areas or focus on 1 or 2 areas of interest? Perhaps Nick, you could answer that for us.
Yeah, certainly, Tom. I don't think there's a need to be interested in every single practice area that we at 3 Hare Court practice in. I think from recollection, there are about 20 or so listed on our website under legal services. So that would be quite a lot to have to reference in an application form. As I said earlier, there simply isn't space to do this. So you have to pick key points accordingly. I do think it's appropriate to identify 2 or 3 or perhaps even 1 or two. I think the point to really mention here, though, is that the unique selling point, as it were, of Three Hare Court is that we are abroad chambers and that you will get exposure across 6 pupillage seats to a wide range of practice areas. So whilst you may have in mind a few areas that do interest you right now, it's important to keep an open mind about that. And I think displaying that open-mindedness in an application form to us will, of course, go down well because we want to see candidates that have an open mind about the sort of practice they might build. For my part, when I applied, I mentioned areas now that I'm perhaps less interested in than I was at the time, but I was applying in an academic context when I was applying as a student, effectively. So it's different when you actually start practicing the law, and you must have in mind that whilst you are in a position as an applicant to display interests, things may change. But whatever you do, any areas you cite in an application form, make sure that you substantiate those interests with relevant experience. Back to my key point earlier, evidence really is important here, and any reviewer of your application will want to see that.
Super, thanks, Nick. Let's have a look at some questions. So what have we got? Question about equality, diversity, inclusion. How is that managed in chambers? Perhaps Ben, as our EDI officer, you can answer that question.
Yeah, absolutely. Equality, diversity, inclusion in chambers is managed with a committee that is specifically set up and meets for that very important topic and area. Within chambers, it is managed generally pursuant to a number of policies, race action plans, fair allocation of work policies, and perhaps more well-known policies that you encounter in most environments, such as maternity, paternity policies. In terms of in a wider sense, in a societal sense, Chambers is very active in a number of endeavours and schemes to promote ED&I at the bar. Lots of our members, many on this call, are involved in 10,000 Black interns, into university, Social Mobility Foundation, and Chambers is a signatory to the Women in Law Pledge. So we are very active. We would certainly like to think in promoting equality, diversity, inclusion within the established bar, as it were, within Chambers, and promotion of all of our members, but also in increasing access to underrepresented groups in a broader sense within the bar.
Super, thanks, Ben. And linked to that is a question we've had. Essentially, what does accessibility look like at Three Hare Court? And perhaps I can sort of take this one. And I suppose the overarching point I would make is that within Chambers, we do everything we can to ensure fairness and inclusivity for all candidates that apply to us, particularly those with disabilities or other needs. I think I would highlight 4 particular aspects of the application process. I suppose first, all of the information we put out about pupillage is clear and transparent, so everyone who is applying knows precisely what they have to do and by what deadline. Second, we will obviously make any necessary reasonable adjustments. So, for example, candidates can disclose disabilities confidentially and request reasonable adjustments such as extra time or accessible interview locations if necessary. We can also provide remote interview options for those who may face mobility or travel challenges. Third, picking up on what Ben has just said, we are very much committed to equality, diversity and inclusion, and that is all the way through to our recruitment of candidates and we try to recruit from diverse backgrounds. And as Ben has indicated, there are a number of members and Chambers as a whole are actively involved in initiatives and charities that promote the furtherance of equality and diversity, as well as access to the legal profession and the bar generally. And then fourth and finally, we ensure that all of those of you that apply to us are supported through the process. Guy Mitchell, who is our Chambers manager, who's not on this call, but whose details are on the website, he's our dedicated contact for pupillage applicants, and he's the person to contact if adjustments are needed or you have any questions about accessibility. Now, I know we've approached the sort of witching hour of 5:45, so we're not going to get through all of the questions that have been asked, but perhaps
Can I take because I think there's a common theme for quite a few of them, which is sort of, should I do this or this in a question? And I think the answers comes back to what Nick said, which is you have got a very limited amount of space to answer a number of your questions. It's sort of what makes you a good barrister, why you're interested in the bar, why you're interested in chambers, why you're interested in particular areas of law. It probably means that you're going to have, maybe several drafts, have a go at, obviously, at each of the answering those questions, and think what is the most persuasive within that time frame, within that short space of words limit. So I think that's the kind of crucial thing to take away. There isn't a dedicated way of answering a question. I think one person said, should I only use one piece of evidence or not, or experience? I've heard it's unconvincing to do that. Well, there isn't, certainly this Chambers isn't such a rule like that at all for any answering of any questions. Is what do you think is the most persuasive example or experience in answering that question? And it is answering that question, I think, is the key point. And then there's just one more about using of judgments. The one thing I'd say about either if you're asked to talk about a recent judgment you're interested, or talking about cases that members of Chambers might have done, is to really know that judgment well. Don't try and blag it, because I've heard many people, either both in written or oral interviews or applications, try to talk a little bit about something and having not really done the research. So if you absolutely should show interest in particular areas of law, and that can obviously be easily done through looking at recent judgments, including from members of Chambers have been involved in, but make sure you just know the key points that arise from that judgment, and don't try and just try and know it well, and don't try and blag it.
Super, thanks, Chris. I can see people are typing answers as we go, so hopefully there will be some typed answers to some of these questions. Just perhaps a few more. Someone's asked, if you applied in the previous cycle, are you adversely affected this year? Absolutely not. No, and I can tell you that we have had people that have applied previously, not got an interview, so absolutely no adverse effect at all. And sometimes it does take more than one application to be successful, because of the nature of the bar and how competitive it is, but don't be put off if that is the case. Someone's asked what makes the culture at Three Hare Court special? Do we look for a culture fit, or what do we look for in a culture fit? We've probably touched on and answered some of this already, but perhaps Charlotte, I can ask you to very briefly address that.
Yeah, absolutely. I don't think there's any one sort of cultural fit per se, and I particularly say that as someone from a minoritized background, because oftentimes that's a perception of the bar that you have to be a particular type of person from a particular background. That most certainly is not the case. But what I would say is that we'd expect people to be personable, courteous, and professional, and that's something that we certainly pride ourselves on as a chamber. So by ways of example, just recently I was at an external event and a very, very senior member of the bar commented on the wonderful Nick Lear and some other juniors in our chambers to say how wonderful and polite and kind he was and others were. So it's that type of cultural fit, if anything, that professionalism, that kindness and that respect for other people in the profession, and just being fantastic at the underlying job and being unapologetically yourself. We want you to bring yourself to work, your personality, just in a professional way, nothing too zany. So just be yourself, be a fantastic barrister, have the competencies down, and be polite and professional and as friendly as the rest of us are, hopefully.
Thank you, Charlotte, and thank you for everyone sort of joining and for everyone participating. I'm sorry we haven't had time to answer all of the questions that have been asked this evening. If anyone does still have a burning question that they really would like answering, don't hesitate to email our dedicated pupillage email address, which is on our website. And just in conclusion, really, I would like to thank everyone that's contributed, members of chambers, members of staff, but most of all, I'd like to thank all of you for joining us on what is a cold and rather dark Tuesday evening in November. I hope that some of what has been said has been informative, possibly even vaguely interesting. If you take anything away from this evening, you should remember that certainly every member of Chambers that you've heard from this evening has been through the process that you're about to embark upon, and they've all come through the other side. Whilst it might seem daunting and at times, no doubt, a little overwhelming, hopefully some of what you have heard this evening will have addressed some of the unknowns and some of the concerns you might have had, and you know a bit more about Three Hare Court and a bit more about what pupillage at Three Hare Court looks like. So I would just like to end by wishing you all the very best of luck, and hopefully we will see some of you at interviews next year. So thank you from all of us, and have a very good evening.